So my name is Kyra Jones, and I'm delighted to be here today to bring our community together to hear from our awesome panel. Today with our panel, we're going to be hearing about the Working for Workers Act. And for this special edition of Communitech's AMA series, we're actually joined by the Honorable Minister McNaughton, Minister of Labour, Training and Skills Development for the province of Ontario, and Member of Provincial Parliament for the Lambton, Kent and Middlesex area. We also are joined by Marcel Kraus, Associate Deputy Minister of Labour, and Rohinton Medhora, Chair of the Minister's Future of Work Committee and President of the Centre for International Governance Innovation here in Waterloo Region. Welcome, everyone. We're so happy to have you here to talk about this important topic. In this very tight talent market, Communitech is happy to host this AMA and provide the opportunity for founders in our innovation ecosystem to ask questions as they prepare their workplaces for the future of work. Some of the topics that we're going to cover today include the right to disconnect, the banning of non-compete clauses, the removal of barriers such as Canadian experience requirements for regulated professions, and other upcoming policy changes to make Ontario the best place to live, work, and raise a family. Before we get started, I just have a couple quick reminders, some housekeeping here. This session is being recorded so that it can be shared as a resource for our founders to reference later. You can find all of our past AMA recordings at communitech.ca. We welcome your questions throughout today's discussion, so please don't feel like you need to hold your questions until the end of the presentation. You can use the chat to send your questions in or the Q&A box. If you're interested in following up after the session to discuss this topic further, you can connect with anyone here at Communitech, like your Communitech advisor or your founder success manager. All right, with that, to kick off our time together, I'd love to invite Minister McNaughton to share with us an overview of kind of this legislation and the impact that it's going to have on making Ontario a great place to work. So Minister McNaughton, I invite you to take it away.
Great, thanks very much, Kyra. It's great to be with everyone this morning. In fact, I think it was just last week I was actually at Communitech. We had a great tour, great discussion, and it's just amazing to see all the innovation happening there. I also want to thank Rohinton, who's joining us this morning. No stranger to any of you, but he did truly heroic work leading the Future of Work panel that we assembled last summer, really to explore a number of issues, and we're going to talk about those this morning. I also want to pay credit to Marcel, who you're going to hear from shortly. She's done so much work working with us over the last few years at the Ministry of Labour, Training and Skills Development. So Marcel, thank you so much for everything that you've done. And I know from my team, we have Alex and Vlad, who look after a policy in my office, and there may be others on the call that I just can't see, but I know you're going to hear from everyone shortly. I also want to say thank you to Communitech, to your member companies, leaders in the tech sector that really have helped us along this journey. We are the first in Canada to move, and the first in North America on a number of these things to really make Ontario the best place to live, work, and raise a family. I've been clear, we're not going back to where we were before the pandemic hit. We have an opportunity to rebalance the scales, to make Ontario just a better place for everyone. So I want to thank Communitech for everything they've done. The ability to embrace change and adapt quickly has obviously become a necessity. And no one is more familiar with this than those in the tech industry. You've always had to adapt, and even more so the last couple of years. Like you, our government does recognize the need to support people in a rapidly changing world. This is why we've introduced just last week our second Working for Workers legislation. And it's really about ensuring that we keep pace with change by providing stronger protections, bigger paychecks for workers, and more opportunities for our workers here in Ontario, and that we continue to keep and attract talent here. Through the first bill, which was in the fall, Working for Workers 1, Ontario became the first jurisdiction in Canada to make it easier for people to relax and spend quality time with their loved ones by requiring most employers to develop right to disconnect policies so that workers can unplug at the end of the day. This change really is about promoting mental health, a healthy work-life balance by prioritizing workers and their time with families, and makes the division between work and personal time clearer. As Kyra mentioned, we also ban non-compete agreements except for very senior executives. While usually not enforceable, these contracts often restricted workers and held back their careers. They also made it hard for growing companies, especially startups and other small firms, to find and hire the skilled workers they need to expand and create even more jobs. Our change bans this unfair practice to help workers in Ontario advance their careers and earn more take-home pay. Additionally, I really think it gives Ontario a competitive advantage in keeping and attracting global talent while allowing employers to continue to protect their intellectual property through narrower clauses. And lastly, and I think this one is really going to be game-changing for Ontario, but we removed internationally trained barriers for professionals that come here, so they don't need the Canadian work experience to get a job in their fields. And it's really interesting, but only 25% of the immigrants in Ontario are actually working in fields that they've studied. So we're really, moving the first in Canada to get rid of these barriers and ensuring that they get into a field that they've studied. It's very important for these individuals. So, they're not driving taxis, not driving for Uber. They're actually earning more money to support themselves and their families. But there's a huge economic importance of resolving this, because there's a recent report by Scotiabank saying that this is costing the economy about $20 billion a year for the next 5 years. So it's important that we move quickly on this, and we've done this. It's certainly a win for workers, business, and our economy. So building on these successful changes, our government last week proposed a new legislation, as I mentioned, the Working for Workers 2, and they would again deliver a first of their kind changes to further protect and support workers and keep and attract the best workers here in the province of Ontario. So this includes protecting workers' right to privacy by requiring larger employers to establish electronic monitoring policies that must be shared with their employees. It also includes clarifying the treatment of IT and business consultants under our labor laws. This would help give these workers the ability to earn more money by charging more for their services and just more opportunities for work here, while giving businesses certainty about their legal obligations. We also know, and all of you do as well, that the gig economy is here to stay. So we're protecting these workers with core rights like minimum wage, guaranteed pay stubs, and the right to have disputes settled here in Ontario. So in closing, everything we're doing is about working for our workers. Through these measures and more, we're going to rebalance the scales and continue to put workers in the driver's seat. This is our goal, our mission. As we build a stronger Ontario, we must move forward and embrace the future of work. And that means ensuring that no worker and their family is left behind. So I know there's going to be a lot of exciting discussions this morning and great questions. I just again want to thank everyone for their input. You've really been a huge help to me and to our government. And our door is always open. If there are any other great ideas, please, reach out to Alex and to Vlad on my team. Again, I've often said that government tends to lag behind technological changes and changes in the workplace. So I'm proud that we are leading not only Canada, but North America on a number of these fronts. And we're going to continue to move forward with positive change. So Kyra, thanks so much, and back over to you.
That's fantastic. Thank you so much, Minister McNaughton. We really appreciate your time today. This has been very informative. And I know it's likely raised some questions in our audience today. And so we'll ask you at this time to hold your questions just for a moment. With that, I'd love to thank you again, Minister, for spending your time here. today with our founders and with our network at Communitech speaking about this important legislation. We're going to get down to a little bit more details, but I know that you have a busy schedule and lots of stuff to do. So we want to let you get back to that, but we do appreciate the time you've carved out for us. This is very special. So with that, I know that we can't see each other really right now, but I'd love to give just a quick round of applause to the minister for coming and making time to join us today to talk about this important legislation. So thank you.
Great. Thanks, everyone. Have a great day.
It feels good to actually clap. Have a good day. It feels good to clap for real. We don't get to do that as often right now. So it feels really nice. Get those endorphins flowing. So that was very helpful to get this kind of overview of this legislation and the awesome impacts that it's going to have on workers and putting workers first. Now I'd like to introduce Associate Minister Marcel Cruz. Marcel is going to share more about this topic in a short presentation and give us a little bit more of a detailed walkthrough. Marcel, I'll turn it over to you.
Okay, thanks very much, Kira. I think my assistant is going to project. Here we go. All right. So we can go to slide 2, please, Ewan. Okay, so yeah, the minister gave a good outline of what's in the 2 bills that we're going to talk about, but I'll just go into more detail and, of course, happy to take questions. So as the minister mentioned, the ministry recently introduced 2 bills under its what we're calling Working for Workers agenda. So the first one, Working for Workers Act 1, was passed by the legislature in December of last year. And the second bill was introduced February 28th, and it is currently making its way through the House and through legislative committees. So broadly, the bills are intended to do 3 main things. One is to increase worker mobility, both domestically and internationally. The second is to provide more protections and clarity to workers. And the third is to increase Ontario's competitiveness. So we're going to talk today about the items that we felt would be of most interest to this audience. So go to the next slide, Ewan. So these first 3 items that I'm going to talk about were all part of the Working for Workers number 1 bill that was passed by the legislature in December. So the first issue is the policy on disconnecting for work. And it's been kind of, in popular parlance, I think, been referred to as right to disconnect. So what the law requires is that employers with 25 or more employees create a written policy with regard to disconnecting from work, and they have to share that with all of their employees. The measurement of whether or not you have 25 employees is done on January 1st of each year, so that's the relevant date. Disconnecting from work, pretty broad definition, basically means not engaging in work-related communication. So emails, telephone calls, video calls, reviewing messages, that sort of thing. So to be clear, it doesn't create a right to disconnect per se. So it doesn't say, after 5 o'clock, you have the right not to check your email. And the main reason for that is that we know that every workplace is different and has different requirements. And every time we create a one-size-fits-all rule around hours of work in particular, we immediately get requests for dozens of exemptions and special rules. So the requirement is for the employers to create a policy. They will have flexibility to tailor the content of that policy to their business reality. So for example, the policy could include things like expectations around response time for emails or encouraging staff to put out of office notifications that say they'll respond the next day. The ministry publishes online something called the Guide to the Employment Standards Act. If you Google that, it'll come right up. It has more information about this and about all the other topics in the Act. So really the only strictures, I guess, are those that have been in place a long time under the Act around maximum daily, weekly hours, vacation, overtime, that sort of thing. Other than that, it's pretty flexible what the employer puts in their policy. And the ministry would only enforce that there is a policy in place. We would not enforce the content, or we would not enforce or investigate a claim that says, oh, the employer's not abiding by its policy. In terms of timing on this one, so if the employer had 25 or more employees as of January 1st of this year, they are required to have a policy in place and distributed to employees by June 2nd, so 6 months. So June 2nd is the key date this year. In years going forward, if they have 25 on January 1st, then they have to distribute a policy by March 1st of that year. And anytime they hire new employees, they are expected to share the policy with them within 30 days of them being hired. Okay, I'll go to the next slide, please. So the minister mentioned the ban on non-competition agreements. This is fairly straightforward. The employers are prohibited from entering into non-competition agreements with employees or even prospective employees. And if they do, the agreement is deemed to be void under the legislation. The definition of non-compete agreement, again, pretty broad. Any type of agreement that would prohibit the employee from engaging in any activity in competition with their employer after the relationship ends. There are some exceptions to that, not many. I think there's 3. First of all, any agreements entered into before the legislation was introduced, so before October 25th of 2021, any of those past agreements are fine. They're exempted. They're allowed to continue. There are exceptions around sale or lease of businesses or partial sales, and also exceptions around what are called C-suite executives. Other than that, it's a broad prohibition. One thing I would note about this is that what we hear in the tech sector quite a bit is that California has had a ban on non-competition agreements since, I think it's like the 1870s. And some people allege that that contributed to the rise of Silicon Valley. So we're excited about this one. We think it positions Ontario well in terms of being a competitive jurisdiction and attracting startups and entrepreneurs. I should mention that employers are still allowed to have what are called non-solicitation and non-disclosure agreements. So those are narrower than non-compete agreements. So, you're still, your clients, you're still protected in terms of people trying to poach your clients or to share confidential information. Next slide, please. So the fair access to regulated professions and compulsory trades, very descriptive name, actually. That's exactly who the Act applies to. So regulated professions are things like law, accounting, human resources, engineering, so on. These are professions that basically you generally need a license or a certificate of some type to enter, and generally you need to be registered by a regulatory college that regulates the practice or the industry. It also applies to compulsory trades. Again, I think there's 23 compulsory trades, things like electricians, plumbers, hairstylists, sheet metal workers, people who have to have certificates of qualifications and pass exams to practice in their trade. One of the biggest barriers to new immigrants practicing in their regulated professions has always been what's called the Canadian experience requirement. And this is a requirement in some of the legislation that governs these regulated professions. It basically says that practitioners have to have a certain amount of Canadian experience before they can be licensed to practice in Ontario. That's been a big barrier. And so the legislative change is that the professions are not allowed to have this Canadian experience requirement unless they obtain an exemption from the ministry and from the minister, really, and any exemptions are to be based on health and safety considerations. This prohibition on Canadian experience requirement will come into effect as of December 2nd, 2023. There's also been added to the legislation quite a broad range of regulation making power, and the ministry will be and has already started consulting with the regulatory colleges about things like reducing duplication in language testing, about providing maximum timeframes for decisions on registration, and so on, things like that. And likewise, domestically, in the second Working for Workers Act, we introduced a provision that sets a maximum 30-day time frame for decisions on registration for domestic applicants. So if you have, for an example, an electrician from Manitoba who wants to move to work or to work in Ontario, that the Skilled Trades Ontario would have 30 days to issue a decision on that once they have a complete application. We are, I think, the second province to do that after Alberta, and that is a significant benefit to people looking to work in different provinces. I'll move to the next slide. This one is about clarity for consultants. So some of you will know that there has long been uncertainty and litigation around the employment status of consultants, particularly what we would call business consultants and IT consultants. There are, numerous cases we hear about where people are hired on to work as independent consultants, but then later sometimes the relationship ends or it goes sour, and then there is litigation where they say, actually, I'm an employee and you owe me back vacation pay, overtime, etc. Plus, what the committee heard, and Rohinton could speak to this better than me, but was certainly that many contractors prefer to be independent contractors because it gives them more flexibility, there's tax advantages, and they feel they can earn a higher income. So in order to provide more certainty around this, the bill amended the Employment Standards Act to make it clear that the Act does not apply to business and IT consultants if they meet 3 criteria. So if they provide their services through an incorporated company or a registered sole proprietorship, if they have a written agreement whereby they'll be paid at least $60 an hour, and they are actually paid that amount. So if they meet those criteria, the Act does not apply. They cannot be considered to be employees for the purposes of the Employment Standards Act. This will take effect January 1st of 2023 to give the industry a bit of time to adjust. Okay, next slide, and almost done. Electronic monitoring. Sorry, the minister touched on this briefly. The key issue that we were confronting was really a lack of transparency for employees over how and when they are being electronically monitored by employers. And this became especially relevant during the pandemic because of the number of people working from home and concerns about privacy in that space. So similar to the right to disconnect, if this bill passes, employers with 25 or more employees would be required to create a written policy and share with staff. What needs to be in that policy is simply three things: how and in what circumstances the employer may electronically monitor employees. So, for example, how might they do it? Are they using software that monitors keystrokes? Are there GPS trackers on company vehicles? That sort of thing. They need to indicate in the policy the purpose for which the information can be used. Generally, that may be to track productivity, may result in discipline up to and including termination. And finally, just the date that the policy was prepared. Employers will have 6 months from the date of what's called royal assent, which is basically when the lieutenant governor signs the legislation, so very shortly after it's passed, to issue their first policy. Okay, final 2 slides on digital platform workers. So digital platform workers are a new category of workers that we've defined. They are often referred to as gig workers. They are people who provide rideshare, deliver, or courier services for payment through the use of digital platforms. So classic examples would be Uber drivers, Uber Eats, DoorDash, Skip the Dishes, Instacart, those type of workers. So much like sort of the higher skilled, higher end of the spectrum when we're talking about business and IT consultants, there's been a lot of litigation and uncertainty about employment status of these type of workers. In the history of employment and labor law, this type of work through platforms is still relatively new. There's been a big debate and there's been litigation all over the world about, are these workers independent contractors or are they employees? The ministry's concern was really ensuring that these workers have a core group of rights, regardless of their employment status. So to do that, we created a new act that is separate from the Employment Standards Act. It's called the Digital Platform Workers' Rights Act, and it does set out a group of core rights, which you can see on the next slide, please, Ewan. So it has a lot of requirements around transparency, because one of the big complaints was that these platforms are basically run by algorithms that people don't really understand. So for example, people might make $500 one week and $1,400 the next week, and they don't really understand why. They don't understand, why they're offered assignments or not, how the performance rating system works, and what the consequences of that are. So the act, if passed, would require the platform operators to provide written information on these topics. There would also be new rules around pay for these workers, so they would have to have a recurring paid period. They would be entitled to the general minimum wage for time spent working. They'd be entitled to keep their tips, and they would have to receive notice if they were going to be removed or deactivated from the platform. And they would be entitled to have disputes with these operators resolved in Ontario. And that was really in response to a case that went all the way to the Supreme Court of Canada, where there was an Uber driver who was being required through contract to take the complaint to The Hague, which is obviously not realistic for most people. So those are the key things I wanted to go over. This particular bill, the Digital Platform Workers Act, will come into force, assuming it's passed. It'll come into force on proclamation, which means a date to be determined. And that is because there are a number of regulations that have to be worked out before the act would take effect. So that's it for me, Kira. Happy to take any questions.
Fantastic. Thank you so much for giving us some detail about what this really means for people. I'd love to take some time to really to open this up, kind of the conversation to our audience. So I thought maybe like Marcel and Rohinton are here to help us, and there's been some questions that were submitted before the event. So I thought I'd kick it off with a couple of those. But if you do have a question that comes up, I think that the best way to do it in this case might be that you raise your hand and I can call on you, because I don't see a chat box right now. So my first kind of question that I'd love to ask, and this is maybe for Rohinton here, we got a number of questions about why is there that banning of non-competes? And so I'm curious, how did the committee come to determine that the banning of non-competes would level the playing field for workers in Ontario?
Sure. Tara, first, let me say how nice it is to be with you at Communitech. And before I answer your question specifically, let me make three broad points, which might sort of also inform some of the answers to some of the other questions. The first is that this field of sort of addressing gig work and the digital economy and labor markets in the digital era is brand new. By brand new, I mean, we simply don't have the conceptual understanding and in fact the data for a lot of these things. And that's something to keep in mind as we make policy, that we're operating not in a vacuum, but certainly in a situation in which we don't have decades and decades of experience and evidence on which to base. The second point I'd make is that any sort of, and I say this as someone who doesn't speak for government, I just say this as a policy analyst, that as we address these issues, we have to be prepared to take a step and then revisit and modify and move forward stepwise. And so my third and obvious point is that I'm not speaking for the government when I address these issues. Now, on non-competes, that's a very good example of my first point. When we met with some 700 or so individuals and organizations over the summer, one thing we kept hearing is that there is a talent shortage, that firms sort of compete with each other for talent and for information. And we didn't have a sense of why. The only study we could find is in fact from the US, and this is the one we cite in our report, that something like 30 to 40% of workers are covered by some kind of non-compete clause. Non-compete is an awfully heavy hammer. It basically restricts labor mobility, so it's not good for workers. And by restricting talented labor mobility, it's also not good for firms and for competitiveness and for all of us, therefore. And so we suggested, based on what we heard and based on what we read, that we could address the worst of the ills of this by saying, let's not have non-competes. And what the government has done is sort of nuance that in I think, a very sensible way by saying one can still sort of exempt very senior and extremely talented people who are key to a certain breakthrough technology. You can also limit some of the competitive disadvantages that go with excessive labor mobility by having non-disclosure, non-solicitation agreements. So we're not completely taking away the rights of employers who've trained and perhaps provided secrets to keep doing so. But we thought that non-competes was an awfully heavy way to go, and based on evidence elsewhere, it appears to be overused. We don't have there, however, the data for Canada or for Ontario. And I think this is one of these things that we should be thinking about as well.
Great. That's very interesting. I love to hear how you kind of came to these recommendations. It's awesome and insightful. My second question is for Marcel. I think that founders, some of the questions that we received are around how this applies to employees who aren't necessarily covered by the work provisions under the Employment Standards Act. So I was wondering if you could just speak to how legislation in these Working for Workers Acts, such as the right to disconnect, apply to those workers.
Yeah, no, that's a great question. Actually, the right to disconnect new requirement applies to all employees. So employers have to share the policy and have a policy vis-a-vis all employees. So even if so for example, many IT workers have, I can't remember, they're exempt or they have special rules around hours of work and so on. They still have to have a policy that applies to them. Now, the employer does not have to have the same policy for all of its staff. It might have a different one for certain groups, but it still applies to them.
Fantastic. I am curious if we have anyone in the audience. I have some other questions that were submitted beforehand as you registered. So, but I wanted to open it up. Does anyone in the audience have questions? If you do have a question, you just need to hit the reactions button and then you can raise your hand and I'll be able to call on you. So Scott, what is your question?
Hi there. Thanks everybody for the input. It's helpful. I may have just missed part of this. I think it was about the right to disconnect. Did it say that there wouldn't be like an enforcement team that comes around? Not that we're looking to evade it, but I found that to be unusual.
So basically, I mean, we certainly do proactive enforcement on occasion, but in terms of complaints, like most cases are complaint driven. And what I was trying to clarify was the requirement is to have a policy. It's not about what's in the policy or is the employer complying with the policy. So we wouldn't accept complaints about that. We would accept a complaint that there isn't a policy.
Yeah, okay, that makes sense. Thank you.
Yeah. Sure.
Great, thank you, Scott. Do you have any other questions? Or?
It's worth mentioning.
Oh, Rohinton, go ahead.
You know, in a case like this, the point isn't, as the minister said, or I think it's Marcel that said, that somehow this is all about saying that at 5:03 I'll stop checking my emails. It's simply about making sure that every firm above a certain size has the internal conversation about what kinds of norms you use. Now at CG, you know, many of us travel, we work in different time zones. It is totally possible that I might send an email to my staff if I'm in Europe at 2 a.m. for them. Doesn't mean I expect an answer by 7 a.m. their time. It's simply to accept what sets of internal culture that you have, what kind of business model do you have, and what kinds of norms do you want to sort of set around these things. And it's going to take months, if not years, for us to get our heads around what this new work environment looks like. And that's why I think sort of Tom's question and Marcel's response is the right way to look at it, that this is not about complaints and then penalties. At the first step, this is about simply having the conversation and the norms and policies in place so that we also perform more effectively as a result.
Yeah, yeah, things have changed, certainly. Yeah, we feel it ourselves, and having a little more open dialogue rather than some assumptions from all ends is probably useful.
Exactly.
I will jump in with an unrelated question. It's about the regulated professions. Are there, is there going to be an impact on residency timelines? So if these certifications for external professionals are going to happen faster, is that, I don't know, fast track things like getting people their permanent residency? I know for us, that's definitely a limiter in the way we can hire people from different parts of the world who have just emigrated.
Yeah, well, I'll say something and then Vlad might want to jump in because he's more expert in this area. But my understanding is that that falls under federal jurisdiction. So unfortunately, the province doesn't have the power to address that. Vlad, am I right?
Yeah, you're completely right, Marcel. I mean, that is a good question, but there's sort of two elements to this, right? First one is Ontario's regulatory environment when it comes to the credentials that foreign trained professionals have coming into the province, as well as, you know, people from other provinces coming in. And then there's the immigration aspect itself. Our office is handling a certain element of that, but that's largely done in tandem in partnership with the federal government. So we are allocated a certain amount of, you know, spots for immigrants with certain professional qualifications to come in and so on and so forth. But what we're doing in this bill is really targeting the people that are already here. They're already residents of Ontario. They have certain education, professional background from foreign jurisdictions. Question is how to get them employed in that respective profession when there are so many barriers. So that's what we're trying to really address here.
That makes sense. Cool. Thank you.
Excellent. I'd love to open it. Does anyone else have any other questions? You can feel free to raise your hand. While you're thinking, I'm going to pick up on something that I heard Rohinton say around the need for this legislation to really not be like an enforcement way of going about this, but more around establishing norms in different organizations. And so I'm curious, I think with the pandemic, a lot of our work life has definitely changed. And we're seeing, for instance, here at Communitech, I see a lot of organizations hiring across different time zones. And that wasn't necessarily a thing that we saw as frequently prior to our pandemic. So how did the pandemic accelerate the need for this legislation to better encourage boundaries for work-life balance in Ontario? And this is kind of a question for both of you, so you can choose who starts.
Well, I can start and then.
Sure.
So, you know, I think that, you know, having personally worked from home for most of the pandemic, I think there's a sense that it's harder to draw a bright line between, you know, work time and home time because you don't have that break for a commute, right? Like you don't, that's sort of been a mental transition. Well, like now I'm going home and I'm on home time. You don't have that. So I think that's one thing, but Rohinton may have, I'm sure he has better thoughts on that, having consulted with a lot of people.
No, I mean, I don't know about better, Marcel, but I would say this, and I think you might agree because you've been with the ministry a long time, that the issues we covered in the Future of Work panel actually predate the pandemic because they were driven by technological change, which has, in this digital era, has been with us for at least a decade, if not more. And so we had already been thinking, by we, I mean at CG, probably in governments and elsewhere, certainly you at Communitech, about the security and privacy and well-being and mental health implications of connectivity, the digital divide, which is still a real thing, not just in other countries, but in Canada. And then along came the pandemic, which, as I always say, sort of put octane to these issues. And so we went from having something like, and this is one of the imperfect sort of statistics we do have in Canada, something like 8% or 10% of Canadians say they mostly work from home. That number during the pandemic shot up to 30, 33, 35%. There's an upper limit, by the way, to that, around 40%. You can't have more than that. And so the pandemic has sort of put reality and a real-time impetus on things that governments and firms were sort of grappling with anyway. A lot of the legislation you see, I'd argue, is timely even if there had been no pandemic. Right to disconnect, non-compete, algorithmic transparency, certain types of minimum wage for certain hours worked. These are not pandemic related, but the pandemic has kind of perhaps created the public policy climate for them to be dealt with more effectively.
No, I agree with that. You're absolutely right that, many of these issues have been in existence for quite a while. I think in terms of the right to disconnect and the transparency around employee monitoring, I think that the pandemic has heightened the interest or sort of the public policy attention on that, because you have a lot of people working from their homes who were not before. I mean, you always, my experience is obviously in the public sector. So, management has long had work phones and laptops and so on, but the average civil servant did not. And so they weren't answering emails or being on calls in the evening. And so that has been quite a change for some people. But yeah, it accelerated the attention on things. It didn't, the conditions were underlying before, you're right.
Work from home, and the second category, especially in urban areas that sort of the pandemic drew our attention to, is the delivery folks and all the sort of gig workers who enabled us to stay at home and not have to go out shopping or go out eating. And I think that sort of woke us up to how many of them they are, what their work conditions are, and how they really live and work.
Yeah, absolutely.
That's excellent. Excellent. I know that we're kind of approaching our 11 o'clock time, so I wanted to give a last kind of call. I haven't seen anyone join the queue with their hand up, but I'd love to be able to kind of close our time together with thinking about the future too. So we have seen, I've heard you say that there's been some issues that have been accelerated, like pre-existing, but they've really come to the forefront during our experiences in the pandemic. What do you think we can expect from Working for Workers 3? Are there any other concerns that were expressed to the committee through their research that the tech ecosystem can expect to be addressed in additional legislation?
Well, the legislation bit Marcel can speak to. I have absolutely no insights on what's in the pipeline. And I don't speak for government, but, and I don't expect that just because a panel made 21 recommendations, we should expect all 21 to be addressed. But broadly, let me say that there's 2 or 3 things in our panel that we heard that would be worth thinking about, and perhaps this government or others are. One is the series of issues around lifelong learning and making learning more accessible, particularly for marginalized groups. There's a set of observations we have there. The second is the more creative and efficient use of digital platforms in gig work to match labor supply and labor demand. And the third is a quality of life issue. And both the minister and Marcel have made the point, which I fully endorse, that workers' rights and competitiveness go hand in hand. They're not antithetical. If they were, Haiti would have the world's largest inflow of investment. It doesn't. There's a reason. And so the points we make about connectivity, public and other forms of transportation ease, distance health, distance learning are also part and parcel of that set of issues that goes with the future of work.
Marcel, do you have anything to add?
I mean, I agree with what Rohinton has said. I think generally, I think there will be continued focus on workplace mental health. And I do want to say to folks that there are some excellent resources out there on that, particularly the Canadian Mental Health Commission has quite a bit of information for employers on that. I think portability of benefits and provision of benefits to more employees. The minister has already announced that we are looking at creating a portable benefits system for workers without traditional access to traditional employer provided health, dental, vision, things like that. And, I think there will, labor and employment law will have to continue to adapt to innovation in the economy. And I think probably the biggest issue jurisdictions are facing across the world is how do you adapt traditional legal interpretations of employment status with new methods that are being created in the economy. It's off the top of my head.
I know that we have just a couple minutes left here. Scott, I want to ask you, is your question short or is it long question?
Very short. Did you say
Okay,
there's
go ahead.
$60 per hour threshold on that employment status for consultants?
Yes.
Yeah, so anybody less than that, they just don't even apply to the rule.
Well, anybody less than that, they wouldn't automatically be exempt from the Employment Standards Act. So, you know, they could still make a case that they are an employee or an independent contractor, depending on how their arrangement is set up. But the idea of the change is if you can show that these three factors are in place, then the act will not apply to you. And so the idea of having the income threshold is that this is really meant for higher skilled, higher paid IT and business consultants, and to prevent sort of abuse of that exemption, if you want to call it.
Understood. Thank you.
Great. So we have about 3 minutes left. So I thought maybe I'd invite Rohinton and Marcel, if you want to give a very quick closing thoughts on kind of how you see this legislation impacting work in Ontario. And so I'll invite maybe Rohinton to go first with your closing thoughts, and then Marcel, and then I'll close out our session.
My closing thought is things I've said already, and I just underlined that this sort of legislation is leading edge in almost any jurisdiction of the world. I can think of different jurisdictions that have done one or two or three of these things, but not all of them as a collection. And I think, and I say this as a nonpartisan, the government of Ontario should be commended for having taken this package of issues and moved it forward. Why? And that's my second closing point, because as I said before, competitiveness and our quality of life and workers' rights go hand in hand. And I think this is going to show that that is indeed the case.
Excellent. Thank you, Rohinton. Marcel.
Well, that's a great question. You know, I do think something Rohinton said that, you know, this is cutting edge legislation. I mean, I've been in labor and employment policy for quite a few years, and we are the first jurisdiction in Canada and in many cases in North America to be doing some of these things. So, you know, will it be perfect in the first instance? Probably not. It'll be iterative because we will learn, and we'll learn from the type of folks who are on this call and getting feedback about how things are working on the ground. You know, that's when you're a first mover, that's the danger, is you're probably not going to get it 100% right first time, but you know, bold steps. We're really wanting to make Ontario a leader in protecting workers, but also in competitiveness.
Excellent. Thank you so much. This has been really helpful session to understand this legislation at a deeper level and really think about how it impacts our founders and the wonderful organizations and companies that they're growing. So I wanted to thank everyone for joining us today. And also thank you to the Honorable Minister McNaughton, Associate Minister Krause, and Rohinton Medhora for joining today. It was so lovely to have you with us, and I hope everyone has a wonderful week. And as always, this recording will be available afterward if you want to review anything that you heard. Have a great week, everyone.
Thank you.
Bye.